my lords and my ladies. I propose to make a short legal submission on the approach which I invite the court to take legal questions for it. I'm going to say just a few words about justiciability and then to make two very short specific Scottish points.
You might have to speak up a bit.
I do apologise, my lady.
Well, those don't necessarily help amplify your voice. They ensure that it's transmitted worldwide, but they don't necessarily amplify it.
I'll try and remember that, my lady. Could I invite the court to have before it the case of Kennedy and the Charity Commissioners? It's number 2 in the short in the bundle of supplementary materials lodged on my behalf. I think the court should have it in blue covers.
Yes.
Tab 2, and I'm sorry, I don't understand there to be an MS number. And perhaps my headline point is to invite the court to take the view that it has the institutional competence and responsibility of exercising its ordinary judicial review jurisdiction to protect fundamental principles of the Constitution, no less than it has that competence and responsibility to protect individual rights. And in the case of Kennedy, I draw to the court's attention the passage in the opinion of Lord Mance, with whom Lords Newberger and Clark joined, at paragraphs 51 to 55, where he gave there was quite a detailed discussion of the variable intensity of review. And I commend that whole passage to the court, but I draw to the court's attention in particular a passage at paragraph 55, page 509, letters B to D, where His Lordship Lord Mance said this: "The right approach is now surely to recognise, as De Smith suggests, that it is inappropriate to treat all cases of judicial review together under a general but vague principle of reasonableness, and preferable to look for the underlying tenet or principle which indicates the basis on which the court should approach any administrative law challenge in a particular situation. Among the categories of situation identified in De Smith are those where a common law right or constitutional principle is in issue." And he goes on to discuss the principles in issue in that case. And in the same case, and I should mention that Lord Sumption, at the outset of his opinion, specifically agreed with the reasoning of Lord Mance. And then in my Lord Carnwath's opinion, at paragraph 245, my Lord Carnwath observed, as Lord Mance points out, there is authority for a closer or more intense form of review or anxious scrutiny in some contexts, particularly where fundamental human rights, such as the right to life, or constitutional principles are at stake. So I found on those passages as support for the proposition that this court, that when considering the approach to judicial review, where constitutional principles are at stake, this court should calibrate the intensity and approach to review in a manner that reflects the importance of the issue, just as it does when fundamental rights are at stake. The judges of the Inner House in the Cherry case referred to Lord Sumption's observation in Pham, that to the effect that there is a sliding scale in which the cogency of the justification required for interfering with a right will be proportionate to the importance and the extent of the interference. And the court has the case of Pham at tab 38 in the Cherry bundle, starting at MS 2556, And the particular paragraph is at 106 in Lord Sumption's opinion at MS 2590. And I invite the court to consider the whole passage in Lord Sumption's opinion between paragraphs 105 and 107, and also my Lord Reid's observations in the same case between paragraphs 113 and 118.
Could you give us the MS numbers of those paragraphs?
Indeed, my Lord. Lord Reid's observations are at MS 2593.
Thank you.
Lord Sumption's are at MS 2590.
Thank you.
And it's in volume 4 of 5 at tab 38 in the Cherry Bundle.
Yes, I think it's fair to say that some of us have been not very keen on sliding scales. I mean, in Yusuf, I think I was rather rude about them, and agreeing with my colleagues.
I understand that, my Lord, and I also understand the ongoing issues around the approach to be taken to review, but I do found on these authorities as support for the proposition that at least where individual rights and constitutional principles are at stake.
Yeah, we don't need a sliding scale to say that where constitutional principles are at stake, we should exercise our greater degree.
Indeed, my Lord. And in my submission, one looks for a cogent justification that reflects what is at stake. And in my Lord Reid's speech in FAM, at paragraph 114, my Lord Reid observed that in cases involving the exercise of discretion where fundamental rights are at stake, and I do invite the court to take the view that also where constitutional principles are at stake, a rigorous approach is required, which involves elements with counterparts in an assessment of proportionality, such as that an interference with a fundamental right should be justified as pursuing an important public interest, and that there should be a searching review of the primary decision maker's evaluation of the evidence. And I say, my ladies and my lords, that what is at stake here is a fundamental principle of the Constitution, namely the principle of parliamentary accountability. Indeed, I think my Lord Carnworth in Miller at paragraph 149, MS 2596, described parliamentary accountability, in my submission correctly, as fundamental to our Constitution. So we have that principle at stake. We have a decision which abrogates the mechanisms of accountability for a period of 5 weeks, which in the context of the short period before the 31st of October and the time-critical nature of that period is in my submission, a significant period. Lord Brodie in the Inner House was correct so to characterise it. And we have a time when the actions and decisions of the UK government are likely to have momentous consequences for the future of the United Kingdom. So I invite the court to conclude that having regard to the effect of this decision in that context, irrespective of its purpose, that it's a decision which calls for the most cogent justification. And I invite the court to subject the decision to a rigorous and searching review, to use my Lord Reid's phraseology. The court has the material before it on justification, and perhaps I can just make these brief remarks, that the justification for prorogation to bring the parliamentary session to an end and to pave the way for a Queen's speech does not provide a cogent justification for what in my submission has to be justified here, namely the prorogation for a period of 5 weeks. We know from the material that a prorogation to pave the way for a Queen's speech is typically very, very much shorter. And my learned friend, the Advocate General, accepted that it would have been possible to achieve this by way of a prorogation immediately after the usual period of conference recess. So the justification for prorogation doesn't justify that which in my submission has to be justified here, namely the duration of the prorogation. And I invite the court to take the view, like Lord Drummond Young in the Inner House, that no substantive justification has been advanced for that duration. As Lord Kerr, I think, has observed in discussion with other counsel, there's an explanation, perhaps what one might call a defensive answer, that only 7 sitting days will be lost compared with the usual conference adjournment or recess. And for three reasons which the court explored with my learned friend, the Advocate General, that explanation is no answer. First of all, because recess or adjournment does not remove all the mechanisms of accountability. Committees may continue to sit, questions may continue to be asked, and as someone who maybe asked questions in the Scottish Parliament and who is called on to give evidence to committees, I certainly take those seriously as mechanisms of accountability. Secondly, the decision as to whether or not to have an adjournment, and if so, for how long, would be in the hands of each House. And as I understand it, as far as the House of Lords is concerned, recall during recess is in the hands of the Lord Speaker, following consultation with the government. And thirdly, the loss of 7 sitting days, in my submission, should not be regarded as immaterial in the present context. At the time when prorogation was announced, I understand that there were 35 remaining sitting days, of which the prorogation absorbed 20. Sir James Eadie emphasised that every prorogation has the effect which it has, disabling the mechanisms of parliamentary accountability for its duration. But in my submission, prorogation, when it takes place in ordinary course, in usual times, does not involve a material interference with the ability of Parliament to hold the executive to account, and will be readily capable of justification with a view to ending the session. The House of Commons briefing paper that the court has before it describes prorogation in ordinary times as, quotes, formal and uncontroversial. That's at MS 1063 in box 2. And we know that it's typically shorter than this prorogation. Whatever might be said of this prorogation, it's certainly not uncontroversial, and my submission is not merely formal. So in my submission, the approach that the court should take to review of this decision is signalled, signposted by the 2 authorities to which I've referred. Let me say something briefly about the question of justiciability. Perhaps the first point to make is this, that if I'm right, or indeed if my learned friend Lord Panic is right, then it's possible to apply perfectly orthodox judicial review techniques to the decision at hand here. There are standard tools in the judicial toolkit which the court can reach for and can apply. There is no want of judicial or manageable standards. The second point is, in my submission, the reliance on the separation of powers on the question of justiciability in the abstract does not advance matters. The separation of powers is predicated on the accountability of government to Parliament. And the question that the court has to grapple with here is how it should deal with a prerogative power, an executive power, which during the period of its application removes the mechanisms of accountability. And in my submission,
if dissolution is non-justiciable, as Lord Roskill tells us, how do you distinguish prorogation?
well, in my submission, at least in modern times, and I don't pretend, my lady, my lords, that I've examined the history here, dissolution paves the way for a general election. It returns matters to the electorate. By contrast, and indeed there are conventions reflected in the Cabinet Office manual about the conduct of government after a dissolution and pending an election. Prorogation, on the other hand, maintains the government in office without the mechanisms of accountability to Parliament during the period of prorogation. So I say there is an important and significant distinction between the two powers.
Could I just press you a bit more on that? Because from the government's case, their researchers suggest that the only statutory obligation before the Fixed Term Parliament Act, that was, the only statutory obligation was to hold summons a Parliament 3 years after the dissolution of the previous one. If that is right, and like you, I haven't had time to check it, then you're really falling back on convention as a check rather than law.
It's a reflection of modern times, and I suppose I suppose that one might have to consider were a government to exercise or advise Her Majesty to dissolve Parliament, but not to proceed to an election, then in my submission one might well have to consider whether legal and justiciable issues arose in the context of a modern constitutional democracy.
It seems to me that is the rational answer.
Well,
because it may be superseded by the Fixed Term Parliament Act, but if we are assessing the prior case law where the highest authorities in this land have taken it for granted that a dissolution was non-justiciable, I look carefully for a distinction between that and prorogation.
well, my Lord Mayor, if there is no distinction to be drawn, then in my submission, were one to be faced with a situation where Parliament was dissolved and the government intended to continue to govern for up to 3 years without any mechanism of parliamentary accountability, in my submission, difficult, serious legal issues would arise of the sort that this court is having to grapple with.
I wonder whether they would be terribly difficult. If action is taken, whether by dissolution or prorogation, to deprive Parliament of its constitutional role, scrutiny, then it seems to me a very tall order to say that they would in all circumstances be immune from judicial review.
Well, in circumstances where the matter is not being returned to the electorate by way of a general election.
Of course, as you point out, the immediately relevant distinction between dissolution and prorogation in conventional terms is that prorogation allows the government to continue without scrutiny, whereas dissolution normally will deprive the government of that facility.
And in my submission, contrary to the view expressed in the Divisional Court, extreme cases test the question of justiciability. Extreme cases test whether the issue is truly one of justiciability, or whether it's actually a question of whether a particular decision is reviewable in the particular circumstances. I have drawn the court's attention in my case to phraseology used by the Strasbourg court to the effect that the effective functioning of Parliament is a value of key importance for democratic society. It's in a case from Turkey at MS 2813, paragraph 227, MS 2868. I do so not because we should need to take any lessons on that proposition, but to invite the court to consider the implications of holding that the executive has a legally untrammeled power to suspend the mechanisms of parliamentary accountability for such period as it thinks fit, for such reasons as it thinks fit, and to reflect on that in its wider wider context. Thinking of extreme cases testing the question, if the UK government's position were to be correct, then it would, for example, have been open legally or it would be open to a Prime Minister on appointment to advise an immediate prorogation. It would have been open to the Prime Minister in this case to advise an immediate prorogation until after 31st of October. Now, that's not what happened, but considering the extreme case helps to test whether it's a question of justiciability. And that example also shows why it is not an answer, as Sir James Eadie suggested, to say that the use of the prerogative power of prorogation is subject to political accountability in Parliament. If one can contemplate an immediate prorogation, then that isn't an answer. And as my Lady Black observed in discussion with Sir James yesterday, accountability after the fact may be too late, depending on the context. I appreciate that in Miller, in paragraph 249, my Lord Carnworth, MS 2729, observed the courts may not inquire into the methods by which Parliament exercises control over the executive or their adequacy. In my submission, prorogation is extraordinary in that it prevents those methods from operating at all during the period of prorogation. And nor is it an answer to say that it is open to Parliament to regulate the use of prorogation and that it has hitherto chosen not to do so, or indeed that it did not do so in the few days that it had available to it when it was sitting. It's of the essence of discretionary power that it operates in areas left to the decision maker by Parliament. It does not follow that this court cannot control such decisions on well-established legal principles. And I recognise the observation of my Lord Carnworth in Sandiford, paragraph 61, that because prerogative powers do not stem from a legislative source, then one cannot find the limits or controls by a process of statutory construction. But as my Lord Sales has shown in his extrajudicial writing, those powers are exercised within a legal and constitutional context, which in my submission does provide a proper basis for the court to exercise its responsibility to review the use of executive power. And if, as the United Kingdom government accepts, a prerogative power may be reviewed where it interferes with an individual right on orthodox grounds, I submit the same analysis must apply where a prerogative power is being used in a way that interferes with the fundamental feature of the United Kingdom Constitution. In the great case of AXA, the court contemplated that primary legislation of a legislature with plenary powers within its statutory framework, the Scottish Parliament, could be susceptible to judicial review if it were to enact legislation which undermined a fundamental principle of the Constitution. And my Lord Reid postulated a fundamental interference with the rule of law. In my submission, there are two fundamental principles. There may be others, but my Lord Reid identified one in AXA. In my submission, the principle of responsible government, founded on parliamentary accountability, is no less fundamental a pillar of the Constitution than the role of the court in upholding the rule of law. My lady, my lords, my ladies, there are two short points I should make from a specifically Scottish perspective. The first is that although this court should proceed on no assumption of a general nature that the prerogatives of the Crown and the generality are necessarily the same in Scots law and English law, or that their effects are necessarily the same in Scots law or English law, this case, in my submission, does not turn on any specialty of Scots law. The underpinning constitutional principles which fall to be applied are the same, as far as I conceive them, in all jurisdictions. And the second point is this. The court will hear from the Public Law Project, and I should just add a short footnote from a Scottish perspective about SIs which are being made by the UK government under the 2018 Act in relation to matters within devolved competence. And that's simply to note that the United Kingdom government has agreed that it will make such instruments only with the agreement of the Scottish government. And there's a procedure under which such instruments are notified to the Scottish Parliament, which then may scrutinise the decision of the Scottish Government to give its consent to the instruments in question. I say that's a footnote because I don't suggest that there's any, it's simply so that the court has the full picture of the SI programme. I don't suggest that it's a separate point to the one which the Public Law Project wishes to make. And I should say that as at yesterday, I was told that there were, so far as the Scottish Government was concerned, only, I say only, that's not necessarily to diminish their importance, 6 outstanding instruments in that category thought to be essential for enactment before the 31st of October. And that 2 had been made already, 2 in addition had already been made by the urgent procedure in a manner, well, without seeking consent of the Scottish Government and without going through the process of scrutiny. And so one can see in those 2 examples the prorogation having an impact on that process of scrutiny. But I simply mention those points for completeness. I should say I've just been told that an update received this morning indicates that the UK government considers that of the 6 formerly considered outstanding, we now consider 4 to be outstanding. So there is a bit of a moving picture, and I mention that simply for completeness. So, my lords and my ladies, unless there's anything in addition that I can say that will assist the court, I'm content to leave my submissions there.
Thank you very much indeed, Lord Advocate. Thank you. Yes, Mr.
Ladies, my lords, members of the court, I represent Raymond McCord, the intervener. We're very grateful to the court for this opportunity to address on this very important constitutional issue. And it's very important in my respectful submission that the Northern Ireland perspective is considered by the court. It's certainly been central in any debates about Brexit, although that isn't a word that has featured an awful lot in the exchanges, the submissions. But I want to tell you a little bit about my client before I begin, because it's important background. He is a victims campaigner and a prominent defender of the Good Friday Agreement and a defender of Northern Ireland's very delicate constitutional settlement. This was not a career that he chose for himself. The reason he's here is that his son was murdered on the 9th of November 1997 at the age of 22. And like many victims of the conflict in Northern Ireland, he's still seeking justice for his son. In many ways, Mr. McCord speaks for the silent majority in Northern Ireland, who want a peaceful and prosperous future, which can really only be based on the Good Friday Agreement and that delicate constitutional settlement which has been achieved. But even though we're here to speak about the Northern Ireland perspective, I'm not here to accentuate the differences between the different parts of this union. Between Ireland and Britain, Ireland and the UK, my client is comfortable with his identity. He has a British passport and he has an Irish passport. He's confident about his Britishness, he's confident about his Irishness, and he believes that in this court there is a commonality of purpose to determine what the rule of law is and how it should be applied. And that rule of law is something which achieves an international standard. And when one looks at international standards, it's important to remember the background to all of this. It's important to remember what the European Union is and remains. It's a peace project. It's a project designed to remove the significance of national identity. It's a project designed to provide for the seamless flow of people, services, goods, and capital, harmonisation of rules, make travel between states as easy as travel between London and Yorkshire, between Belfast and Lisburn. And the Good Friday Agreement itself was premised on continuing EU membership. 576, I don't intend to open it to the members of the court, but the Good Friday Agreement confirms that it, wishing to develop still further the unique relationship between their peoples, this is the British-Irish Agreement, and the close cooperation between their countries as friendly neighbours and as partners in the European Union. In many ways, Northern Ireland is a microcosm of that European peace project. The impact of EU citizenship lessened the importance of national identity. The rising tide of nationalism that we're witnessing is poisoning the harmony between the EU states, and it is directly affecting Northern Ireland's ability to function. Brexit has been recognised as the major impediment to the restoration of the Northern Ireland Assembly. So we're urging the court to look at this legal question in a way that recognises the impact of the impugned decision on Northern Ireland in particular. Of course, it will have a huge impact on the people of Britain. It's without question that the impact on the people of Northern Ireland of a no deal, of the erection of a border, will be devastating.
But Mr. Lavery, we're not concerned with any of that. We are solely concerned with the lawfulness, or not, of the Prime Minister's advice to Her Majesty to prorogue Parliament for a period of 5 weeks. That's all we're concerned with. We are not concerned with when and how and on what terms the United Kingdom leaves the European Union.
I recognise that this is a distinct legal issue, but the context of it and the way that the policy has been framed, the decision of the Scottish court that the decision was taken to pave the way for a no-deal Brexit is important. And it's important to look at whether that was the improper purpose or whether that's simply collateral damage in what was otherwise a lawful decision. We submit that it's important to look at what the ultimate consequence of it may be. And moving directly on to the arguments, we support the appellants in Miller and the respondents in Cherry, and we adopt their submissions and celebrate the diversity of the way in which they were put to the court. We say...
With all those plaudits in mind, can we move on then to the net issues?
Yes, my lord. We say if the government has acted unlawfully, using its power to prorogue, to stymie Parliament, then the court could and should intervene. We say that, as we've discovered in the exchange of remarks yesterday, Parliament has little or no remedy once prorogued. We say this isn't a decision which was taken on high political grounds. In fact, the nature of prorogation to simply start a new session of Parliament is and should be something fairly mundane. It's not without the expertise of this court or judges to examine the decision and whether or not the motive for it is improper. It's only really if the intention or motive is improper, if it really was to stymie the role of Parliament, that one enters into the realm of high politics. If that was the intention, to stymie Parliament, run down the clock, avoid scrutiny, and pave the way for a no-deal Brexit, then that would bring it into the area of high politics. But that does not necessarily mean that it's still not justiciable. And the reasons put forward for non-justiciability amount to, in effect, it has always been thus. And but we say that the court wouldn't be trespassing on Parliament when one is looking accurately at the separation of powers. It would simply be preventing the government from unlawfully trespassing upon Parliament, wresting control from Parliament. And, my ladies, my lords, improper motive is a very simple legal yardstick, and one which this court is well equipped to deal with. But even if the purpose is lawful, even if you don't find in the same way as the Scottish court that it was for the purpose of stymieing Parliament, then, and it's legitimate, then one has to look still at the purpose and effect and the rational or proportionate connection to that purpose. And there are two ways to look at the effect. There is and I want to look at this really from a Northern Irish perspective, the immediate impact of this, the loss of parliamentary time, ability to scrutinise legislation. And as was mentioned yesterday in the Public Law Project, in their written submissions, they refer to now the inability of Parliament to scrutinise in advance regulations, Henry VIII style regulation, Henry VIII clauses under Section 8 of the 2018 Act, and the requirement now that there will be to use urgency procedures under paragraph 5, Schedule 7 of the Act. But there was an important statutory instrument relating to Northern Ireland, which could not, which was about to be legislated upon. And if I could there was an additional bundle today. Yes. Hard copy, yes. There's a piece of page 600, MS 633, internal page 10 of that bundle. There's a letter from the current Northern Ireland Secretary of State for Northern Ireland to Lady Herman, dated 16th of August. And he thanks her for a correspondence of the 26th of July regarding draft statutory instruments in relation to Northern Ireland appointments that would normally be made by Northern Ireland ministers. My priority remains the restoration of the Northern Ireland Executive. However, in the absence of NI ministers, the Government has taken steps to ensure continued good governance and the delivery of public services in Northern Ireland. The Northern Ireland Executive Formation and Exercise of Functions Act provides for me to make appointments to a number of offices deemed to be critical in order to safeguard the quality and delivery of public services in Northern Ireland. Further critical appointments were added to the Act through secondary legislation. There's reference to 8 bodies, and if one looks then at page 13 over the page, there's a table of those appointments, and the very first one at the top of page 13 is the appointment of a chair of the Northern Ireland Transport Holding Company. This is the public transport company for the whole of Northern Ireland. It has a budget of 112 million pounds for capital projects and 83 million pounds in resource. This is an important appointment which simply couldn't be achieved, which was about to be passed, and couldn't be because Parliament was prorogued. And in the second paragraph, the court will see that the executive directors could not fulfil its oversight function, including offering constructive challenge. So important appointments could not be made. The effective functioning of Northern Ireland departments is critical upon pieces of legislation like this because of the absence of the Assembly and an executive in Northern Ireland. If one turns over to page 17, the court will note as well that 25 QCs couldn't be appointed either. But, that may be of less concern to your lordships, my ladies.
Look, the members of the senior bar who are rejoicing in that.
I welcome the competition, my lord.
Of course you do.
These are very important, and there are a string of things like this. There's no reason why this piece of legislation has to be postponed to whatever time. Why it couldn't simply have been fitted into these 7 days that we say are a small amount of time. The other matter is the debates that are required under the Northern Ireland Executive Formation Act. We looked at that act, but there were a number of debates, and we set out at page 9 of the printed case the sort of debates that were prevented from proceeding on the 9th of September, including historical institutional abuse, victims' payments, human trafficking, gambling. And again, these are important matters. They can't be discussed, debated in any local assembly, and the only forum in which that can take place has been removed. But that's the immediate impact of this. But what if the Scottish Court was right and that this was a decision taken to stymie Parliament and pave the way for a no-deal Brexit? The effect of that, whether that's the purpose or not, that will, in my respectful submission, be the collateral effect of this. And if I could ask the court to turn to the joint report, which is in the same bundle, just to put this in some context. And MS 713, it's the part of the joint report. It's internal page 90. It's the part of the joint report which deals with Ireland and Northern Ireland. And this represented United Kingdom policy and approach prior to the change of government leadership. Paragraph 42, both parties, that is the EU 27 states and the United Kingdom, affirm that the achievements, benefits and commitments of the peace process will remain of paramount importance to peace, stability and reconciliation. They agree that the Good Friday or Belfast Agreement reached on 10th of April by the United Kingdom Government, the Irish Government and the other participants in the multi-party negotiations must be protected in all its parts, and that this extends to the practical application of the 1998 Agreement on the island of Ireland and to the totality of the relationship set out in the agreement. This delicate constitutional balance which was achieved. And at the bottom of paragraph 43, last sentence, the United Kingdom also recalls its commitment to the avoidance of a hard border including any physical infrastructure or related checks and controls. 44, both parties recognise the need to respect the provisions of the 98 Agreement regarding the constitutional status of Northern Ireland and the principle of consent. The commitments set out in this joint report are and must remain fully consistent with these provisions. It's really an outline of when one draws on documents to establish what our unwritten constitution amounts to. This is the sort of document which helps in that process. Paragraph 46, the commitments and principles outlined in this joint report will not predetermine the outcome of wider discussions. At the end of the paragraph, they are made and must be upheld in all circumstances, irrespective of the nature of any future agreement between the European Union and the United Kingdom.
I'm afraid you've lost me as to the bearing this has on the validity of the prorogation of Parliament.
Well, this feeds into Section 10 of the Withdrawal Act, which I'm going to take you to now, which is an important safeguarding provision, which was inserted by way of amendment by Parliament, and which reflects the terms of the joint report and the policy of not erecting a hard border on the island of Ireland.
Well, does that have anything to do with the prorogation of Parliament?
It does in a Northern Irish context. If it is done to stymie Parliament and to remove the only protection available to the people of Northern Ireland, Parliament will prevent the erection of a hard border, then it is relevant to be seen in that context.
Well, I think you can say in a sentence, can't you, that if Parliament is prorogued, all of the safeguards, that are particularly important in Northern Ireland, will be lost.
Yes.
Yeah. Well, I think probably we have that point. It doesn't necessarily require terrific elaboration as to how important it is.
Well, I'm not sure then how far the court would be assisted in the particular section of the Yellowhammer report, which lays out the calamity that will befall Northern Ireland. I can't open that to your lordships, perhaps ladies. It's at page 82 of the same bundle, paragraph 18.
Whether or not withdrawal from the EU is a good or a bad thing for any part of the UK, it isn't the issue before us.
I agree, but it's the context of it, and when one looks at justiciability, the context is important. If this is the effect of this, if, as I said, it's the effect in the execution of this decision to stymie Parliament has this effect, then it's important for the court to be aware of it and to put it into that context.
How does it affect legally? How does it affect justiciability? Yes.
Well, I'm afraid this strikes me so far as completely irrelevant to the legal question that the court has, any of the legal questions that we have to decide.
Well, I respect that view, my lord.
As I said, Mr. Levy, your essential point is these are the tangible effects on Northern Ireland by the removal of scrutiny from Parliament. But does it require any elaboration beyond that?
Perhaps not, but I'm really just trying to convey.
I suspect we're all aware of the general contents of the Yellowhammer report.
I'm glad to hear it, but it
myself.
does no harm sometimes just to lay out exactly what is going to happen to Northern Ireland and to have that
Well, the
there.
purpose of this hearing is not to rehearse the pros and cons of Brexit,
No.
either generally or for Northern Ireland in particular.
Well, can I take you then to Section 10 of the Withdrawal Act? Because, and the importance of this provision is that this will be now impeded in its operation because of the lack of parliamentary scrutiny, and it was a provision designed to ensure that there would not be an exit which erected a hard border. It's at MS 13 tab 2 of the intervener's authorities. So these, and this is a section which deals with the government's powers under the Act to make regulations. And very regulations which now will be scrutinised in advance. And they, under Section 10, in exercising any of the powers under the Act, a Minister of the Crown or devolved authority must act in a way that is compatible with the terms of the Northern Ireland Act, and B, have due regard to the joint report, which is a document I opened to the court earlier. So that's a statutory obligation. And then nothing in sections 8, 9 or 23 authorises regulations which diminish any form of North-South cooperation or create or facilitate border arrangements between Northern Ireland and the Republic of Ireland after exit day, which feature physical infrastructure, including border posts or checks and controls that did not exist before exit day and are not in accordance with an agreement between the United Kingdom and the EU. So that is a tangible impact that Parliament will not be able to exercise any of those controls that is provided for itself under Section 10. There was a reference yesterday by Sir James Eadie about whether or not in public law proceedings ministers would necessarily commit to an affidavit. And there may be some distinction between the Northern Irish practice and the English practice. If, in my respectful submission, there is an issue of improper notice or bad faith, one would expect it to be rebutted on oath. Now, that does not necessarily mean that the deponent will be cross-examined. The court will look at it and see whether there's still any substance to the allegation being made. And if it still feels that there is, then it will order cross-examination. Or there are other alternatives open to a court. In one particular case in Northern Ireland, the Secretary of State for Northern Ireland was subjected to a rigorous series of questions by the judge in order to respond on affidavit to the questions raised by the court. So those are, and when one looks at this case, what we do have in terms of the decision is the production of what we would term some self-serving documents, which in fact preempt the controversy that would be caused by prorogation. Interestingly, when one considers those documents, Northern Ireland does not seem to feature the impact of prorogation, either immediate or collateral in terms of Brexit, with no deal. The only consideration really was how much prorogation time could be squeezed into the obligations of the Northern Ireland Executive Formation Act. Now, that may be a material consideration point, but we say that the absence of consideration of Northern Ireland here and in these circumstances is gross. How could it not feature in real terms? The Northern Irish border is one of the only things that stand in the way of Brexit. Parliament has sought by the Section 10 amendment to safeguard Northern Ireland's constitutional position. And it's unthinkable that Northern Ireland wouldn't be taken into consideration in this decision-making process. If there is, as the Scottish court found, a policy that's being railroaded through to leave with or without a deal, then this is the execution of it. It removes obstacles like Parliament. And we say that the language of it, withdraw, do or die, that battleground language would be played out in what is essentially what would be a scorched earth policy in relation to Northern Ireland. It would be oppressive, we say. It would be unconstitutional if that were to be the case when one takes all of that into account. And Section 10 demonstrates the goodwill of Parliament, that Parliament can and will function to protect the interests of each part of the United Kingdom and Northern Ireland in particular. Even in the absence of meaningful representation at Westminster, or perhaps one anti-Remain MP who sits and makes her voice heard. And if the court will permit me, I'll make this point, that leaving with a no deal would be contrary to the terms of the Good Friday Agreement.
Well, that doesn't come within the ambit of this appeal. You're pursuing an appeal in the Court of Appeal in Northern Ireland, which raises this very point, aren't you? And as my lady and my lord have pointed out to you, this is an entirely different context. We're dealing here with the question of whether the prorogation, the decision to prorogue, was unlawful. Now, you've made the point that there are particular effects upon Northern Ireland which have to be taken closely into account. But does your case go beyond that? In the context of this appeal?
In the context of this appeal, when one is looking at the discrete issue, we say that one has to look at the context, I've made that point, and decide the level of scrutiny given that context which the court applies, and that this court has to be conscious of its obligations in respect of Northern Ireland.
Mr. Lavery, I'm really worried about your submissions.
Yes.
So many people are listening to you. Perhaps some of them have just turned on. And they will hear these points, these general points about Brexit and its effect on Northern Ireland, and it may come to an entirely the wrong conclusion, namely that this is what we are looking at. Now, don't abuse our politeness, and don't abuse Lady Hale's patience.
Well, I apologise if that's what I've done. And really, I wanted to put it into context.
You've done that.
I wanted to talk about the unwritten constitution and the documents that provide the context of that, of which we draw upon that. And they certainly indicate, when one looks at paragraph 40 of Miller number 1, lists the combination of statutes and events, conventions, academic writings, and judicial decisions. And Dicey describes it as the most flexible polity in existence. And flexibility is at the heart of that. And we say that the exercise of the power in this context would be an abuse, that it's perhaps uncharted territory for the court, but not forbidden territory. And that the court should retain a flexibility to ensure that Parliament, and I'm coming back to this, that Parliament does retain the capacity to safeguard Northern Ireland's interests. That, and I'm sorry if that got lost along the way, my lord, but that is the essence of our submission. That Parliament, that this court must protect Parliament's capacity to protect the interests of Northern Ireland. Because there's a fundamental portion of the rule of law in relation to consent of the people to be governed, and if that's undermined in any way, then there are consequences. It's not merely a political game, as was suggested, or not, that there are some kind of permissible tricks to gain a political advantage. It's more than that. It's graver than that. It's more serious than that. It's about the power of the government to stymie Parliament. And the context is as the Scottish court said, pushing through monumental constitutional change. That's something which the court has to have regard to. And when one looks at the context of fragile peace in Northern Ireland, my client's perspective, his son was murdered because of this. And it is important to put that into context. He has faith in the institutions of government and in Parliament to protect his rights and the rights of the people of Northern Ireland, and this is what he urges the court to do. And it is lawful for the court to intervene in this area. I don't think I've used up all of my time.
Oh, that's a very good thing.
I haven't used up all of
Don't trouble about that.
patience.
We never ever mind if people take less time than they have indented for. Thank you, Mr. Levin. Thank you.
I'm not sure I've ever pleased you in that way. Can you hear me? I want to go back to first principles and I want to make some submissions on the law. But a good place to start in the analysis in this case is that Sir James Eadie and the Advocate General have accepted that this court can and would act if prorogation were contrary to the terms of primary legislation. It's in a note in writing from them both, dated the 17th of September, page 3, paragraph 4, where they accept it in terms, and my Lord Hodge put it to Sir James Eadie, if the government acts illegally by defying a statute, we can act. Yes, it's primary legislation, yesterday morning. And if you just stop and think about why that's the case, that the court could give a practical and effective remedy on judicial review of a decision to prorogue Parliament where it was defying a statute. What's the constitutional principle that is in play that the court is applying? It's parliamentary sovereignty. And it's in the name of the rule of law, because the rule of law requires that judicial review have that scope. We also know from a note we've received this morning on remedy, and it's paragraph 17, we know that there is a species of declaration that will be the practical and effective remedy on judicial review. Because you're told, you'll have to think about whether you want it in an undertaking, but you're told that that declaration would be sufficient. So we're there so far as remedy is concerned. Sometimes, if courts are concerned and lack any confidence at all in what might happen next, then they give liberty to apply. But a declaration is what is sought in these cases.
I think, Mr. Fordham, there was also a concession before the Scottish courts. I don't know whether the government has withdrawn it, that in certain extreme circumstances there could be justiciable judicial review, which is recorded in the Scottish judgment.
For reasons that are obvious, but we've pinned them down in the three places I've just referred to, in writing in two notes and in response to your question. So let's start here. Sir James, in his reply note to the interveners, paragraph 5, denies that inconsistency with constitutional principles and values is a recognised ground for judicial review. Inconsistency with constitutional principles and values, not a recognised ground for judicial review, they submit. They accept, as we understand it, constitutional right, at least to a point, though whether that's been pinned down is debatable. But you've just seen in Kennedy, Lord Mance and my Lord Carnworth putting together constitutional principle with fundamental right for the purpose of judicial review. And sliding scale intensity, variable intensity is the better concept, and that's IBA, and that's in the bundles. And my Lord is familiar with that because it came from you. We maintain that inconsistency with constitutional principles and values is a basis for judicial review. And can we just look, because I don't think you've looked at it, but you were referred to it, at unison. And unison is in the Miller Bundles, volume 3 at tab 33. And I think if you're electronic, maybe you're clicking on an individual file. But tell me if you're in a bigger PDF, and I will try to help you with an electronic number.
We are picking...
Are you on an individual case?
Individual.
Good, that's good to know. Then I'm hoping I'm going to be able to help. Tab 33 of volume 3 of the Miller Authorities is the unison case, and you will recall it. My Lady Hale, Lord Kerr, Lord Wilson, and Lord Reid were all in it. And that's a case where access to justice is invoked by a trade union, you'll recall, and judicial review succeeds, you'll recall. And it's done on the basis of constitutional analysis at common law, and you'll see it in the PDF at page 26, and in the report at 434, in the judgment for this court of Lord Reid. And there's then an analysis, starting at paragraph 76, of the recognition of the constitutional right of unimpeded access to the courts. Now, remember, it's not a victim of a breach of a right saying, give me a remedy. It's a union, trade union, challenging the way power has been exercised compatibly with the principle of access to justice, a recognised constitutional right. And if you just go back to page 24, to paragraph 68 below C and D, that's the way my Lord Reid puts it when he says, in order for the courts to perform their role, C to D on 432, page 24, people must in principle have impeded access to them, the courts. And that's the principle. And in fact, there have been cases that have described access to justice as a constitutional principle. The House of Lords did it in Anna Frageva. So it's a principle, and there's then an analysis, and the conclusion is reached at paragraph 98, page 32, or 440 if you're in print, that the order that had been made, now that's not a prerogative power, it's a statutory power, effectively prevents access to justice and is therefore unlawful. That's the basis for the court's analysis. And it's a constitutional principle or value or right, doesn't matter, they go together, see Kennedy, and it leads to a successful judicial review based on the common law. And if you want to trace through that it's the common law channel, you can see it at paragraph 64, letter C on page 23 or 431, that it's the common law right of access to justice, and then a judgment of my Lady held in a case called Salim, which was about a procedural rule in immigration, is in the middle of that page at letter E, page 23, page 431. And so, if you go to paragraph 89 in my Lord Reid's judgment, page 30 or 438, we get the conclusion at the end of paragraph 89. And the conclusion already arrived at by the common law, that even an interference with access to the courts, which is not insurmountable, you could go to court, but there were fees that were impeding it, or going to impede it, will be unlawful. And then this, unless it can be justified as reasonably necessary to meet a legitimate objective. And that, of course, is the common law reflecting analysis that's very familiar from rights cases. And if you look at the end of 88, you get the same point on the same page. Citing Daly, Daly is a common law case. The degree of intrusion must not be greater than is justified by the objectives which the measure is intended to serve. And just to add finally to this analysis, this is an analysis of the court that is based on impact. It's not based on you set out to deny a whole load of people to be able to go to court. You could have a case like that. You might deny a passport. You could do it under the prerogative, with the consequence or purpose or known consequence or inevitable consequence, it doesn't matter, that someone can't get to a court. And in this case, Unison, the court is analysing and scrutinising carefully the impact. Have a look just at letter F on page 31 or 439. The question, Lord Reid, whether fees effectively prevent access to justice must be decided according to the likely impact on the fees on behaviour in the real world. And the whole thing's an analysis, objectively, of looking at the impact in order to decide whether the constitutional principle or value has been abrogated or breached by the action that is in question. Manageable standards, absolutely. Straightforward legal principles which involve asking about justification, having analysed objectively impact. And the idea that you can somehow distinguish taking half of my Lord Carnwath in Kennedy and Lord Mance in Kennedy and saying, well, these ones are rights and these ones are constitutional principles, is a very striking position, not least because of the overlap in the language between the two. Where is the case that Sir James Eadie has shown you that says constitutional principle, recognised by a court on judicial review, breached by the executive on judicial review, but not justiciable? That's not a basis for judicial review. And let's just do a quick quiz. No confinement without authority of law, prohibition on torture, the underpinning of legitimate expectation, abuse of power, access to justice. What do those five things have in common? They have all been described as constitutional principles. No confinement without authority of law, the prohibition on torture, the underpinning of legitimate expectation. That was my Lord Hodge in a Privy Council case called Rainbow. Abuse of power itself in public law, and access to justice. All constitutional principles. Now, what could possibly be wrong with this test of accountability? You're not getting into political merits. You're considering the impact objectively. You're looking to see whether an aim's been put forward that's legitimate, and you're satisfied about it. And you're looking to see whether the action is justified by that legitimate objective as reasonably necessary. And that's a manageable standard. And this is, in the end, isn't it, the scope of judicial review that the rule of law requires. And that's a principle that you've hit on when you've looked at judicial review itself and what it's about. And can it be excluded? And who decides whether it can be excluded? And what are you doing when you make that decision? And what you're doing is applying a constitutional principle, the rule of law, and deciding what its limits are. And that's why Carte establishes the principle, in the context of the upper tribunal, that the court will secure the scope of judicial review which the rule of law requires. And that will become, in our submission, the governing constitutional principle applicable to questions as to the reach of judicial review in areas that might otherwise be considered to be contentious. Again, my Lord Carnwath discusses this principle. It's established in Carte. They're all agreed about it in Privacy International. It's in our written submissions, which thank you for letting us put in. at paragraph 3.1. And while we've got cart in our minds, history, as it already is doing, will recall, and this is paragraphs 8.1 and 11.1 of our written submissions, what Lord Justice laws at High Court level recognised about parliamentary sovereignty. It's not limited to the words or even the intent of a statute on the page. It does extend broader, and it extends broader to the idea of needing a court to judicial review the executive tomorrow against standards that have been set in an act that Parliament has made the day or tomorrow. And it extends to the idea, very well established, as Lord Justice Sales explains, it's all in our written submissions, I hope it's helpful, 8.1 and 11.1, the idea which inheres in parliamentary sovereignty that Parliament can't bind its successors. What is that about? It's about the dynamism of ongoing legislative autonomy of Parliament, because parliamentary sovereignty is not narrow, as Sir James argues that it is in the present case. Now, is there some magic, then, about prerogative powers that mean, oh, well, it's different if you've got the prerogative power, judicial review is curtailed, and you can go as far as, does it cut across primary legislation? That's Laker in 1976, which you discussed in Miller number 1. Prerogative power that frustrates a statute. But you can't judicially review prerogative power against constitutional principle. And again, that would be very, very striking, and there's no support for it. But let's just think of an example, because you practice what you preach as courts when it comes to constitutional principle. Let's take one that's applicable to courts. The open justice principle. What is the open justice principle? That would have been quiz question number 6. The open justice principle is a constitutional principle and identified as such in a case called Guardian, which was discussed in Kennedy. So let us suppose for a moment that you've got an inferior court, I'll use that old-fashioned phrase, and a judicial review. Now let's suppose it's non-statutory. So it's not exercising statutory powers. You can't point to an enabling act. Are the powers judicially reviewable against constitutional principle as a matter of principle? Not only are they, but we've got the authority. Because Guardian News itself was a judicial review of the Magistrates' Court, and Guardian Media says in terms, and this court has very recently confirmed it in terms, rejecting attempts to distinguish the early authorities. What you've accepted is that that constitutional principle applies to non-statutory powers. It's neither here nor there. And I hope you've now got just 2 things I wanted you to have this morning, because these are points that have come up during the hearing. And if you have, I hope you've got Dring. And if you have got Dring, you'll see from page 442, paragraph 41, constitutional principle of open justice applies to all courts and tribunals exercising judicial power of the state. So there's...
Flagged as Cape in my version.
Oh, is it? I'm so sorry. That's my mistake. Cape. Have you all got Cape?
Somewhere, yes.
Have enough of you got Cape? Carry on.
Well, I can remember it quite clearly.
Well, it's all yours. So, for those of you who weren't there or who can't remember it, and I'm trying not to take it personally, page 442, paragraph 41, discussion, the constitutional principle of open justice applies to all courts and tribunals exercising the judicial power of the state. And the point about the neither here nor there came from Guardian. If you just go back 2 pages to 440, paragraph 36, and if you want Guardian, we've got Guardian as well, but the fact that magistrates' courts were created by statute was neither here nor there, paragraph 70 of Guardian. Guardian's a judicial review. Now, what about Sandiford? Because there's been an idea and it's been discussed, and Sir James showed you an authority, the Air Centre case, and tried to persuade you that improper purpose isn't available for a prerogative power. I just want to address that very briefly. Sandiford is about fettering of discretion. That's all it's about. And you've seen in Sandiford, which is volume 3, tab 32 of the Miller Authorities, Lord Mance was talking about no external originator. Lord Sumption at 83 was talking about no empowering act as the derivation of the power. And the point they were making is the same point that my Lord, Lord Sales, persuaded a Court of Appeal, including my Lady Arden, about in a case called Elias, which is adopted in Sandiford. And it's because the court decides that that principle of fettering or non-fettering is necessarily linked to whether you have a statutory power. We know there's no general principle of that kind for the prerogative. We never have had Laker Airways in the 1970s. And that's all that decides. Now, you might say, could there be other principles in public law which would also be switched off or modified? And there could be. Let's take an example. A case that we've cited in our written submissions of Chetnik. Chetnik is a principle which you'll all remember. It's 52, tab 38, and it's Lord Bridge at page 872 of Chetnik. I don't need to go to it because you'll know it off by heart. Power is held by the executive on trust and it's not unfettered. And he went on, approving Wade and Forsyth. It can only be exercised for the purpose that Parliament intended when conferring the power. That bit is not going to work in a judicial review of prerogative power. And you'd be into Elias territory and you would be into Sandiford territory. And I'm not ruling out that there might be others, but you wouldn't have a problem with the first part of that. Indeed, it's accepted, and my Lord Sales has written about it, that prerogative power has to be exercised in the general interest, in the public interest. It is held on trust, but you haven't got an empowering act. And so the most important paragraph of Sandiford is paragraph 65, in which it's said in terms, the other principles of judicial review remain available. And that wasn't...
62, did you say?
65.
65.
It's Miller 3, tab 32. Can I go back to it if I get time? Because I'm worried I'm going to run out of time and I've got some things I need to cover.
You've not got a lot of time left, Mr.
I know. Now, that wasn't said in a vacuum in Sandiford by my Lord Carnwath, because one of the cases you had in mind was Bancourt number 2, which was cited in that case. Bancourt number 2 is worth just having in mind, volume 2, tab 23 of the Miller bundles, because that was the case, and you've seen Lord Hoffman at paragraph 35, which was about not GCHQ, the exercise of prerogative power under an instrument, but prerogative power to make an instrument for the British Indian Ocean Territory. And Mr. Crowe argued, you'll see it at electronic pages 10 and 11 in the report at 462G to 463F, straight along Sir James Eadie lines in that case. And unanimously, the court said, Lord Hoffman was paragraph 35, Lord Bingham 71, Lord Roger 105, Lord Carswell 122, Lord Mance 141. Not only judicial review is applicable, but the grounds for judicial review are available. No good reason why not. Didn't matter that it's an instrument rather than exercise of power. Exercise of power, a fortiori. Lord Mance says, no good reason, and every reason why it should be. And so just pause there, and suppose you had an instrument for that island that is subsequently made, which on the face of it is a marine protected area proclamation issued by a commissioner in accordance with Her Majesty's instructions through the Secretary of State. Just suppose. And just suppose you had an argument that it's for an improper purpose. There's no primary legislation or statute to reach back to. And then let's suppose you had judgments below and there was an issue about undisclosed documents. And this court had to decide whether those documents could have made a difference to the conclusion on that very ground, improper motive, for the prerogative. Well, you had it, because that case was Banku number 3. And you can see it in the headnote, right in the middle of the headnote. It's the other case of the two that I've just given to you. So, in principle, what does this legal landscape look like? So, if you've got Banku number 3 alongside Cape, you'll see at letter F in the headnote that the challenge, which came all the way here as to whether it had viability and whether it would have made a difference, which was available to prerogative, was improper purpose, improper motive. And you don't need a bribe or bad faith to get to an illegitimate purpose. So stepping back, what would it look like in principle then as a justiciable matter for the court to be considering a question of prerogative power of prorogation? Well, first of all, the court would recall that constitutional principles and their delineation is your job. That's your responsibility. Secondly, you would be concerned to examine impact, the unaccountable executive. You wouldn't stop, as lower courts might, with this isn't justiciable, and you'd ultimately ask that justification question. And you might coin it in this way. Was it reasonably avoidable? Is there a reasonable justification? Is there a legitimate objective which justifies what has been done, or for that matter, what hasn't been done? And the reason why it's worth doing that is because you might find it of interest that if you look at the case that's possibly the closest we've got, and it's a written constitution case and it's a Privy Council case, and it's quite a good story. It's a case called Bob and Manning. It's a story my Lord Hodge told in a case called Dumas, Volume 1-3 of Miller, and Lord Kerr, Lord Wilson, Lord Palmworth were all in that case. So you know about this case and you know this story. But Bob and Manning, which is Authorities 1 tab 7, is in the context of Lord Bingham at paragraph 15 on page 10 of Bob and Manning, whether you're electronic or paper, considering whether what had been a challenge to retaining office without accountability, there was no functioning Parliament, that was the problem, whether that could have been a challenge to a failure to dissolve Parliament earlier. And what's interesting at paragraph 15 is Lord Bingham doesn't say, well, of course not, you couldn't have that. And that's dissolution. He goes on to discuss the wholly proper reasons, paragraph 15, 6, 7, 8 lines. He then says, at the end of that paragraph, there were reasons of informed political judgment as to whether the public interest required another dissolution. Nothing to suggest the power was exercised inconsistently with the Constitution. Then paragraph 17, really important. The board agrees with the appellants that irresponsible, unaccountable government is the antithesis of the democratic model. But periods of that are sometimes unavoidable, as here, and an extended period of such government was not reasonably avoidable here. And this is in the context where at paragraph 12, he's picked up on what he described as brave and memorable observations of the Supreme Court of India, and they're brilliant, about the court's role, where you are delineating constitutional principle. And so it is worth just having in mind that one can see on first principles a framework where you don't stop. Lord Bingham didn't stop. He didn't say, well, of course, stop there. You could never consider that in a judicial review. That case was a judicial review. and so you don't, and there are manageable standards that are applicable. And yes, written constitution and all the rest of it, but let's take the stabilisers off, and applying first principles, the bike still rides. Now, you've got material from the Public Law Project. You won't be hearing from them, but you've got it in writing, and it is important material about bills falling away. We've dealt with it in our written case at paragraph 19, and also statutory instruments without curtailed scrutiny. You know that 3 major bills in joint responsibility areas fell away, and the clock is ticking, the time to do the repair work. You know the situation in relation to 11 statutory instruments made on a make it and ask questions later basis, with 35 more anticipated, many of those in devolved competence. And you know, because you heard it in relation to Scotland, and you've got the document for Wales, that there's an intergovernmental agreement, tab 53 of the supplementary bundle 2 in Miller, it's at pages electronic 1164, 1165, that there are provisions about liaising and getting consent. So these bills went forward on the basis that the Welsh Assembly had consented that that matter of dual responsibility was going to be done by Westminster. And these statutory instruments, which are supposed to be scrutinised ahead, were also supposed to be the subject of prior liaison and agreement. That's gone out of the window. And so those are parts of the context so far as the impacts are concerned. This is not a judicial overreach case. This is a quiet, principled, judicial insistence on the maintenance of parliamentary sovereignty with its ongoing legislative autonomy, function, and with its ministerial accountability to Parliament function, the very 2 functions that the executive tell the courts day in, day out, are the reasons why courts should stay where they are and not get into those of decision-making. You can do your job and stay with what you're doing, applying legal and constitutional principles, because other things are accountable to Parliament, and Parliament can always legislate. Finally, we say, please, not the position that this is justiciable in principle against the constitutional principle of parliamentary sovereignty, but not judicial review in this case. If not in this case, then the words justiciable in principle are, we would respectfully submit, empty words. With gratitude to you, those are the submissions on behalf of the Counsel General.
Thank you, Mr. Fordham.
One or two very quick preliminary points. First, can I say on behalf of John Major that he's extremely grateful for the opportunity to intervene in this case and to make a submission. Secondly, by virtue of his identity, can I make it plain that his intervention has nothing whatever to do with the argument for or against Brexit. It is all to do with his wishing to ensure the maintenance of the council government of parliamentary sovereignty. Thirdly, can I say that we support the legal analysis advanced by my learned friend Fordham and my learned friend Will Panic? And can I fourthly refer you to the 3 documents that are relevant to what I have to say, and they are the first written submission of Sir John, which you'll find at the Provisional Court Trial Bundle at 9, pages 6 to 61, and PDF number is 104 to 193. Apparently I can't be heard at the back. I'm trying to address the court. Yes,
It's more to do with the transmission.
It's not every day I move to the right, I must assure you. So I've already referred the court to the written submission. Secondly, the witness statement of Sir John Major, which is in that same bundle, tab 18, tabulated 123 to 133, PDF numbers 176 to 186, and then finally to the supplemental written submissions made to this court, which are in the Supreme Court bundle 6, tab 6, and they are PDF numbers 192 to 201. Now, can I then quickly move on to the evidence? We are, I think, unique in this case for having put in a witness statement concerning evidence about how the power in question is actually exercised, and you'll see that in Sir John's statement. And we say it's significant for two reasons. First, because it constitutes the unchallenged evidence of a former Prime Minister and long-serving parliamentarian as to what the purpose, the power of prorogation serves, how it's generally exercised, and what considerations might have a bearing on its use, in particular as to the period of the prorogation. Secondly, because it contains clear and unambiguous allegation in evidence and supported by evidence that the reasons set out in the documents put before the court by the Prime Minister can't be true and complete reasons for the decision. Now, see, for example, in the introductory section of the statement, at paragraph 5, just the last few lines, where Sir John says the inescapable inference to be drawn is that the prorogation is to prevent Parliament from exercising its right to disagree with the government and to legislate as it sees fit. Now, this is important, we say, because of the discussion yesterday as to whether there is an expectation in judicial review proceedings that the decision maker will explain the reasons for the decision in evidence. Now, whether there is or is not room for doubt about whether such evidence is to be expected in the ordinary course, I submit that it was more or less accepted by my learned friend Sir James Eadie on behalf of the Prime Minister that where an allegation of this kind has been made, it would be normal for there at least to be some kind of witness statement in response. And in this case, we've made a direct allegation in evidence that the reasons stated in the documents don't stack up. And there's been no witness statement in response and no real reason provided why not. Let me then quickly move on to a brief overview of the statement. In his statement, Sir John explains at paragraphs 9 and 10 that prorogation in our constitution is usually routine. I think my learned friend Mr. Fordham used the word mundane, and in practice leaves the Queen with no discretion. And indeed, the Leader of the House, Mr. Rees-Mogg, said as much, I think, in an interview. At paragraph 12 of the major statement, he addresses the significance of the distinction between prorogation, adjournment, recess, and dissolution, and he draws from the Institute of Government briefing paper as well. At paragraphs 18 to 24, and particularly at paragraph 23, he identifies three main reasons which have been put forward in the government's documents and explains why each of them is a perfectly sensible reason for proroguing, but no reason at all for proroguing for 5 weeks, let alone for 5 critical weeks in a period in which time is of the essence. Then we go to paragraph 26 onwards, so the second half of the statement, where Sir John identifies various pieces of evidence which suggest that the decision was in fact motivated to a material extent by a desire to prevent Parliament from interfering with the Prime Minister's policies during that critical period. Prorogation, we say, is different from dissolution. In his submissions, my learned friend Sir James relied on the dissolution of Parliament as what he called a core example of a prerogative power that was considered before the Fixed Term Parliaments Act to be entirely non-justiciable. He submitted that there was no material difference between prorogation and dissolution, so that even though there is no authority suggesting that the power of prorogation is non-justiciable, the same should apply. My lords, my ladies, there is a world of difference between the two. Put simply, dissolution overrides Parliament in favour of the electorate, and prorogation overrides Parliament in favour of the executive. It's the direction of travel point, and this was a point brought up in questioning by my Lord, Lord Hodge, and my Lord, Lord Kerr. The power of dissolution allows Parliament to renew its mandate from the electorate. It brings the state in contact with the ultimate source of democratic legitimacy. There are citations from Dicey, which I won't go to support that. But prorogation, by contrast, transfers power in the other direction, not closer to the source of democratic legitimacy, but further away. So from the perspective of a principle of parliamentary sovereignty, first, a power of dissolution necessarily involves an interference with Parliament, but the principal effect of that interference is to ensure that the political basis for parliamentary sovereignty remains intact. A power of prorogation, of course, also involves an interference with Parliament, but it's a matter purely between the organs of the state. There's no reason, we say, why it should be treated as unreviewable simply because the power of dissolution was once not reviewable. Now may I quickly look at...
What principle is there for not reviewing the dissolution? What principle?
Well, it's now dealt with by statute.
No, but the authorities which spoke of this in the past predated the Fixed Term Parliament Act.
That, I suspect, is because there was, in the Victorian era and before, a much greater actual respect, as opposed to fictional politeness, played to the role of the sovereign in person, as opposed to the crown of Parliament or the executive through the administration.
You think it's a historical hangover then, rather than a principle?
In some senses, and I don't wish to be impertinent, but a lot of how our constitution has developed over time is a series of fudges. Arrangements are made which are politically convenient. And the example that my Lord has just addressed to me is, I suspect, one of those. We exercise through necessary polite fictions in order to enable our constitution to develop and to work. Let me, if I may, come on to permissible purposes. The defendant, the Prime Minister, in his submissions repeatedly poses the question, how is this court to determine what is permissible and what is impermissible? He submits that the decision to prorogue inevitably involves a degree of politics, at least as to timing, and how is the court to decide what is good or bad political reasoning? In our submission, that entirely misses the point. The question is not whether the motive is political or whether it's a good political or a bad political reason, but whether the prorogation contravenes a legal principle. Now, as we said in our first written submission at paragraph 7, in the case of a statutory power, the most obvious way of determining which purposes are legitimate or illegitimate is to consult the statute. But the statute, or a statute, isn't the only source of legal rules. There are some legal principles which we submit are sufficiently important that they're properly to be regarded as governing the purposes for which any power, statutory or otherwise, may be exercised, and parliamentary sovereignty is one such principle. It requires no specific statutory underpinning. It's inherent in the constitutional order. Now, my learned friend Sir James submitted yesterday that parliamentary sovereignty was limited, in his words, to the principle that it is an unduly narrow, to the principle that Parliament can make or unmake its own laws. But we say that is an unduly narrow formulation. But in any event, it's enough to make the point, because Parliament cannot make or unmake laws if it isn't allowed to sit. But Parliament doesn't only exercise its sovereignty through legislation, it exercises it through summoning papers and people, it exercises its sovereignty through holding the government to account on the floor of the Houses of Parliament. It even holds its sovereignty by the power of contempt, holding people in contempt of Parliament. You'll remember the Sir John Junior case in 1957, where he appeared at the bar of the House. You may also remember that in 2016, 2 newspaper executives involved in the phone hacking scandal were held in contempt of court for telling untruths to a parliamentary committee. And you will remember in March of this year that Mr. Dominic Cummings was held in contempt of Parliament for failing to come before the Culture, Media and Sport Select Committee. Now, the relevant question we submit is the power being exercised in a way which materially impedes Parliament's ability to discharge its functions in the way that it considers important or appropriate. Now, my learned friend Sir James submits that any prorogation involves an interference with Parliament's ability to discharge its functions. Well, of course, that's true, but is it a material interference? That's the question that we need to think about. If it's for a very short period, as modern prorogations have been, well, then there is no material interference. If it comes at a time when there is no particularly pressing legislative business, for example, no looming and time-crucial critical deadline outside Parliament's control, anything which Parliament may wish to do during the period of prorogation can equally be done in the new session, if necessary with retrospective effect, so that it's prevented from acting in the short term. But ultimately, it can still do whatever it wishes to do. Now, my lords, my ladies, Sir James submitted that this issue would involve the court in a series of impossible questions. How long is too long? What's reasonable and what's unreasonable? Now, one could make the same submissions about other areas of the law, of negligence, the concept of proportionality, the defence of honest opinion, and so on. The law recognises standards which it may not be possible to lay out mechanically in the abstract in a way which covers all possible permutations, but which it is possible to apply to a given case. Can I then quickly turn to political motives? The defendant has relied on 2 examples of prorogations which it said were done for political gain and which therefore illustrate that prorogation for political gain is a legitimate exercise of the power. He cites the case in 1948 when there were 3 sessions in quick succession in order to amend the 1911 Parliament Act into what became the 1949 Act. Well, as my Lady Hale and I think Lady Arden also commented, that was legislation passed in order to facilitate the work of the democratically elected House. And it had the overwhelming support of that House, as we say in our written submissions at paragraph 2 in the second set of submissions. Now, Sir James said, of course, well, that's a frustration of Parliament as a whole. Wrong, it wasn't. It was in exact compliance with the 1911 Act. The Parliament Act 1911 provided that the bill had to be passed in 3 successive sessions within 2 years. And that's precisely what the Parliament in 1948 did. So nothing done in 48 frustrated the will of the House of Lords, and as I say, it was very much in accordance with the will of the Commons. The second example, referred to in a tweet by Nikki DaCosta in July, just before she came into government, about a fortnight, 14 days before she came to government, but touched upon gently by my learned friend Sir James, is the prorogation in 1997 at the end of the John Major Parliament. And it was suggested that he had prorogued for base political reasons. Again, wrong, and I haven't got time to take you to the facts of it, but if the court would look at the documents which are appended to his statement, you will find a letter from Lord Heseltine to the Times the other day, which completely cuts that off, destroys the factual basis of that. But if anything, the fact that the allegation was made and that the prorogation for that alleged reason was controversial suggests that it would have been regarded as an impermissible use of the power. In other words, we say it runs entirely contrary to Sir James's submissions. Why should the court stop the prorogation when Parliament has an opportunity to do what it wants? Sir James has submitted that there's no need for the courts to intervene because the events relating to the Ben Bill have shown that it can legislate quickly when it wants to. Now, as my Lord Sales has already made the point that there is only so much time available, but there are 2 further reasons we submit why that is no answer. First, the reason that there are processes for considering and developing legislation in both houses is because legislation generally benefits from scrutiny. Legislating in a hurry leads to the old cliche, what is the law that Parliament passes most often in a hurry? The law of the unintended consequence. Second, it's just not the amount of time available, but when that time is. Events may develop between now and the 14th of October. Parliament may wish to legislate in early October in a way that it couldn't have foreseen in late August. On a similar note, my learned friend Lord Keane submitted that the courts shouldn't step in where Parliament could have prevented the prorogation but didn't do so. Well, it's not at all obvious, we say, that Parliament would have been able to prevent the prorogation. First, there is the requirement for Queen's consent. We've seen that from Erskine and May and the submissions of my learned friend Mr. O'Neill. That could have been withheld. And secondly, even if the Queen's consent was required, Parliament could simply have been prorogued before any bill that sought to prevent it became law. The logic of the justiciability analysis is that the courts would have nothing to say about that situation, despite it being an obvious frustration of Parliament's will. I think it's also suggested by my Lord Carnworth that Parliament could have passed a vote of no confidence in the Prime Minister, a suggestion taken up by my learned friend. But that wouldn't actually have addressed the vice of the prorogation, and probably would have made matters worse. First of all, Parliament would have lost up to 14 days in deciding whether another person could form an administration. Or it could have led to the dissolution of Parliament, in which case the whole thing would have had to start again. Time and the risk of wasting time at a time when time is a very, very scarce resource is something that I think that this court can take account of. Now, my Lord Wilson yesterday asked the stark question, if we can't control what's going on, who can? And it seems to me that these are, and I think my Lord Sales also dealt with the question of the danger of politicising the Queen. These points are aspects, we submit, of a broader submission that this court shouldn't intervene in decisions to prorogue because they involve matters of politics. Now, the immediate and obvious response to that is that the reason the courts leave political matters alone is because they are subject to political control, and there can be no political control of a decision to prorogue if the body that would exercise that control has been prevented from acting. We've identified in our written submission several examples of exercises of the power of prorogation which would frustrate political control. But in answer to that point, Sir James relies on two other possible types of control. First of all, practical constraints. He talks of the need to vote money to pass the Armed Forces Act. But as we point out in our second written submissions at paragraph 7, those controls all meet the fundamental obstacle that they depend for their effectiveness on the Prime Minister placing a higher authority on the orderly running of the country than on the achievement of his political goals. All it would take is a Prime Minister who is happy to see funding for public services lapse or for the Armed Forces Act to expire in order to achieve his goals, and the controls would be useless. And we submit it would be a strange constitution that protected against a conscientious executive, but not against a reckless one. Secondly, the prospect of the sovereign's ability to refuse consent to a prorogation. The short answer to this point is this. If the courts should not interfere because the matter is too intensely political, that's all the more reason why it would be wrong for the sovereign to be required to step in. I think that's Nails' point. Now, the reasons that the government had given in this case, as I've mentioned, Sir John's evidence explains the factors relevant to the decision to prorogue and why the reasons in the documents put forward by the government explain why there should be a prorogation, but they don't in any way address the reasons why it must be for 5 weeks. Now, there are two things which are most obviously missing from the 15th of August Da Costa briefing paper to the Prime Minister. First, while there's an attempt to explain why the 14th of October would be an appropriate day for a Queen's speech and therefore an appropriate date for the session to end, for the prorogation to end, there's no attempt at all to explain why early September would be an appropriate date for the prorogation to begin, a point drawn out by Lord Kerr yesterday. The logic of the briefing paper is equally consistent with a decision to prorogue on the Friday before. The inference must be that there must be some other factor which meant that the decision maker wanted the prorogation to begin much earlier. Secondly, the total absence of any suggestion that it was recognised that the prorogation might be controversial. Now, taken in isolation, that might not be surprising, but it's necessary to consider the author. As my Lord Wilson pointed out on the first day of this hearing, this is a person who a few weeks before writing this briefing paper, which gives the impression that the decision was entirely logistical, was writing in The Spectator on the 29th of June, and again that is in your papers, about the possibility of a Prime Minister running down the clock in the lead up to the mid-October European Union summit and describing prorogation as a nuclear option. For our part, we don't buy the suggestion from my learned friend Lord Keane that the woman who wrote the article in late June had a different character or mental state to the woman who wrote the briefing paper and who was closely advising the Prime Minister once he had taken office. Let me now quickly deal with the...
Well, you are more or less out of time.
I am. I think on my...
I've got 2 minutes to go. Well, yes, but you started early.
Well...
However, we might, I think, indulge you with your 2 minutes.
Would you mind? I'd be very, very grateful. I really am on my last few submissions dealing with inferences. We say there is credible prima facie evidence that the reasons in the documents aren't the true and complete reasons. There's been no evidence adduced to rebut that evidence. There's been repeated requests for such evidence or for an explanation of why it hasn't been provided at the highest levels, including in questions to the government, to the Prime Minister in the Commons. In those circumstances, it would, we submit, be very difficult not to infer that the reason is that any evidence which could be given would be highly adverse to the Prime Minister's case. That the inference which in any normal circumstances would be readily drawn. We submit that that inference is all the more justifiable in these circumstances, that's to say where there is recent evidence of the Downing Street press office having been misleading in its announcements. We give the example in our first submissions, at paragraphs 20 and 21, of these. The 24th of August 2019, in response to reports that the Prime Minister was considering prorogation, a spokesman said that the claim that the government is considering proroguing Parliament in September to stop MPs debating Brexit is entirely false. A quotation drawn attention to by Lord Hodge yesterday. Of course, that's technically consistent with the Prime Minister's case, but as a denial to the reports that prorogation was being considered, it's not the whole truth. It's what we used to call swearing by the card. And whatever its intent, its effect was plainly to mislead. We know that because it misled even a member of the Cabinet, the Culture Secretary. But we also know, of course, that the day after that, the Defence Secretary gave the game away, and you have the interview of him in the papers. In other words, this isn't a case where statements made other than through the formal court process can be taken to be the whole truth and nothing but the truth and at their face value. Finally, my lady, I'm grateful to you. Sir James referred yesterday to the risk of cross-examination as one reason why the Prime Minister might have been reluctant to give a statement himself. It's our experience that applications for cross-examination are rare and successful ones are even rarer. If the court did grant an application to cross-examine the Prime Minister, it only could be done if the court was satisfied that there is a sufficiently serious prima facie case that the evidence was untrue. If the evidence that is given is credible, there's no risk of cross-examination arising. If it's not credible, it would be odd if the Prime Minister could insulate himself from challenge by deciding to put in no evidence at all. Lady, I apologise for going over my time and for garbling, but I hope that throughout my submissions you've been able to gather broadly what I've been on about.
If I thank you for them, Lord Garble, that doesn't mean to say that I accept your self-accusation of garbling. Thank you. Well, according to the timetable, the court is now due to adjourn until 2 o'clock, when we will look forward to hearing from you, Lord Keane, and then from Lord Penn.